Welcome. This is General Effective Day. This is just a real quick update. This is not intended to replace our other limited jurisdiction updates, but today is General Effective Day. It's the day we've been waiting for, September 24, 2022. We'll start with protective orders. Orders of protection are now 2 years. So you don't have to have that awkward conversation that if it was served before September 24, it's only 1 year. Everything's going to be served after September 24, so they're now valid for 2 years. It does not affect injunctions against harassment. There are also new rules for those of you who do emergency orders of protection. And the real interesting thing is the lifetime injunction for felonies. This is not an injunction against harassment. It's in its own statute, 13.7.19. This is a function of being sentenced for particular felonies. And I'm going to call it felonies. You'll see why in a minute. There is a tiny sliver that might affect limited jurisdiction courts. I would argue that it really doesn't. But there just is a tiny argument. And again, it's not an injunction against harassment. It's not an order of protection. It's going to be something that is done at a felony sentencing. And then for those victims who've been sentenced before September 24, they can petition the court. The Supreme Court is still working on that process. It's not going to work through the online system, the online portal. How it does affect us is that definition of harassment for an injunction that was added last year has been removed. And why I say it really only applies to felonies, this is the criminal section definition for serious offense. And everything on here is a felony except possibly E or F, sexual assault or any dangerous crime against children. I would argue that if those are worthy of a lifetime injunction, that those would be charged as felonies. But again, there is a tiny argument that that might apply to us. Just stay tuned. The crime of harassment has been amended as well. And for a domestic violence act, so it does change the definition there. You should become familiar with that new definition. And so, of course, there was an emergency petition, R220030, that adopted those changes. It could be made permanent or will be made permanent in December. Let's talk about evictions. We are now required to seal eviction records in certain instances. And we are prohibited from collecting eviction answer fees. For juveniles, that little situation that was added last year where it appeared we had to appoint attorneys in limited jurisdiction juvenile matters has been corrected. The juvenile rules and the statutes now say that the action has to be commenced with a petition, not an ATTC. So that has been fixed. And just a couple other things that new statute that had been added about videoing police encounters has been paused by a federal U.S. District Court judge. No one showed up in court to argue that that was constitutional. And just one more thing, as of yesterday, interest rates are now 7.25%. Remember, every judgment must have a numerical interest rate, and you should leave the interest rate on stipulated judgments as stipulated, or else it's not a stipulated judgment. But other judgments, you should change the interest rate because you are responsible for applying the correct legal interest rate. All right, have a good day, everybody.